Hello and welcome back. In the last lecture, we talked about the remedies after penalty, that is appeal, revision and review. We particularly talked about the case of R.K. Gupta versus Union of India, in which the provision for review under Rule 29 was amended and a new separate rule for review of the orders made by the President was included. Today, we will talk in detail about how to handle appeals, what action can be taken under revision, what are the steps which are necessary to be taken. We will talk about appeal, revision and review separately. Appeal is to the higher authorities, as we discussed earlier. Revision is also to the higher authority. It includes the president and includes the appellate authority, but review is only for the president. So only the president can review his own orders. Otherwise, nobody else can review his own orders. So let us talk about appeal first. This is what we are going to cover. We are going to cover first orders against which no appeal lies, which is governed by Rule 23, then orders against which appeal lies, and who is the appellate authority, what is the time frame, time limit for making an appeal, and finally form and content of the appeal, and how to consider an appeal, and what are the final outcomes of the appeal. This is what broadly we are going to cover. Now coming to orders against which no appeal lies. You remember in our last lecture we said that any order made by the president, no appeal lies, because he is the highest executive. So there is nobody above him. So obviously there is no appeal from the order of the president. So in whichever case the president is the disciplinary authority, you cannot appeal. Any order which is interlocutory in nature or step-in order, there is no appeal against which it lies. Finally, order for final disposal of disciplinary proceedings other than suspension order, no appeal lies. Step-in orders and interlocutory and orders, obviously no appeal is allowed, because this is not the final order of the disciplinary authority or the inquiring authority. This is during the process when the inquiry is going on. Any order made by the inquiring authority during the course of the inquiry under Rule 14, because inquiry officer issues various orders for, let us say, postponement of inquiry, or not allowing any defense document to be produced as an evidence. So various orders the inquiry officer passes. No appeal lies against all those orders. Now, what are the appealable orders? So it is a very long list, but very quickly we will go through it. Orders of suspension, appeal lies. Order of penalty, obviously appeal lies. Order of enhancing penalty. So if in the appeal the penalty is enhanced by the appellate body, again an appeal lies to that order. Orders adversely affecting the following: pay and allowances, pension, conditions of service, it could be anything, appeal lies. Orders of reversion otherwise than as a penalty. So suppose you are holding a higher post and you are reverted to a lower post, either because there is no post available, or a person who had a lien has come back to that post and you are reverted, or I am reverted, I can appeal. Now, orders against subsistence allowance, during the period of suspension subsistence allowance is paid, so again you can challenge that in the appeal. Orders regarding treatment of suspension period as a duty. So after the period of suspension results in exoneration or some kind of a minor penalty, the disciplinary authority may declare them as duty. Even if it results in major penalty, disciplinary authority may take a decision to treat partially or fully the period of suspension as duty. So it is also appealable. Now, who is the appellate authority is the very important question. Please see the rules. As per the rules, CCA rules 1965, authorities are specified in the schedule or by general or special order. They are specified. For example, for the upper division clerk of the Central Secretariat Service, you can see the appointing authority for the upper division clerk is the deputy secretary or director of the cadre authority, and he can impose all the penalties. So deputy secretary director can impose all the penalties, and the appellate authority is given in the schedule. So this is in the schedule to CCSS schedule. It has been mentioned that for the upper division clerk, it is the secretary of the cadre authority who is the appellate authority. So whenever you want to find out, do refer to your rule. Whether you are in a PSU or an autonomous body, see what is your instructions rule says. I am now showing you the CCS rules 1965. However, wherever no specific officer or official has been prescribed in the schedule, in that case, so where no specific authority is there specified in the schedule, then in that case only you will, the rule says, for group A and B, to the authority specified in the schedule. Where no such authority is specified, to the appointing authority, if the order appealable is made by a subordinate authority. Else it goes to the president. So in case of group A and B, if there is nothing mentioned in the schedule, it goes to the appointing authority. If he is below the president, else to the president. For group C and D officers, to the authority specified in the schedule, as I told you, else immediately the next higher authority. That means whoever had issued the order of penalty, immediate next above is the appellate authority. Now, these are the general provisions. The Rule 24 also provides a special provisions for if the original authority is holding the post of appellate authority, maybe because of promotion or he has been appointed in that post for in the higher post, then the same man will not be the appellate authority. The appellate authority will be next higher to that authority. For those involved in the associations and JCM, members of the JCM, etc., the rules provides that the appellate authority will be the president, so that he gets the protection of the highest authority. So in respect of persons penalized due to activities as an office bearer of an association, the appeal lies to the president. Now coming to the next issue, what is the time limit for filing an appeal? Please remember, it is within 45 days from the date on which the copy of the order was delivered to the appellant. So if the appellant receives a copy today, he has to decide to file an appeal within 45 days, beyond which the time limit, it is not permitted to file an appeal. However, appellate authority can condone if he is satisfied about the cause of the delay. So in other words, after 45 days, the government servant does not have a right. Now he is at the mercy of the appellate authority. Only if the appellate authority feels that there is sufficient cause for the delay, he may allow. Otherwise, he may not allow. What should be the time limit you have seen? What should be the content and the form of the appeal? Now, number one requirement is that appeal is to be submitted by the appellant and in his own name. Collective appeal is not permitted. So 5 people join and sign and submit an appeal, that is not permitted. It has to be individually submitted by the appellant, and it has to be submitted to the appellate authority with a copy to the original authority, and it should be complete and contain all material statements and contentions relied by the appellant. So it should be self-contained. Whatever are these contentions must be available in that appeal, and no disrespectful language. What is the role of the original authority now? Suppose I passed the penalty order and the appeal has been submitted to my higher authority. So what is my role? So the role of the original authority is important. The authority which made the order appealed against shall send its comments together with the records to the appellate authority on his own. He will not wait for the appellate authority to give him directions that please submit me the file with your comments. He should automatically, without waiting for the appellate authority, send the comments, his own comments, to the appellate authority. Now, what should the appellate authority do when he receives an appeal? Now, so far as suspension is concerned, Rule 27 says, in the case of an order of suspension, the appellate authority shall consider whether the order of suspension is justified or not and confirm or revoke the suspension order. That is about suspension. Now, in case of penalty, Rule 27 says, in the case of appeal against penalty or enhanced penalty, what will he check? He will check whether there is procedure or rules followed or not. The first thing appellate authority should do is whether the procedure has been followed or not. He must see whether during the inquiry he was given reasonable opportunity, he was allowed to bring his witnesses, he was the procedure as laid down in the rules have been followed or not. If it has not been followed, then whether it has resulted in violation of any provision of the Constitution. You know, in the Constitution, you have seen my first video lecture. that in the constitution it says that number one, that penalty can be imposed only by the person who appointed that person. Nobody subordinate can do it. That is number one. Second is he must be given reasonable opportunity of defending himself. He must be informed of the charges and given a reasonable opportunity. So any part of the constitution has been, the guarantee available under article 311 has been followed or not. Whether it has resulted in failure of justice. So whether, even if the constitution provisions have been followed, if it is a resulting failure of justice, this is what he will check. Now let us say the procedure has been followed, the constitution provision has been followed, but the second issue which the appellate authority must check, and this is very important, is whether the findings of the discipline authority are based on evidence or not. So the findings of the discipline authority are based on the evidence which were adduced during the inquiry. इंक्वायरी में जो एविडेंस आए हैं उसके बेसिस पे ही डिसिप्लिनरी अथॉरिटी ने अपना कंक्लूजन ड्रॉ करा है, या कोई एक्सट्रेनियस कंसिडरेशन या ऐसा कोई एविडेंस उसने ले लिया है जो इंक्वायरी में नहीं आया, उसकी पर्सनल नॉलेज में हो या इंक्वायरी के बाहर आया है. सो दिस इज वेरी इंपॉर्टेंट. डिसिप्लिनरी अथॉरिटीज final conclusion must be based on evidence adduced during the inquiry. And finally, even it is based on the evidence inquiry whether the penalty commensurates with the misconduct of the government servant or not. So the quantum of penalty is what the appellate authority must check, whether it is adequate, inadequate, or severe. And finally, the appellate authority must also, if he feels, if particularly the government servant has made a specific request for a personal hearing, he may provide a personal hearing. Although the Rule 27 specifically does not talk about giving personal hearing to the government servant, but the appellate authority may grant a personal hearing. And the government has also clarified that in that personal hearing, the government servant may be allowed to also be represented by his defense assistant, who was defense assistant in his inquiry. So these are the special instructions issued by government so far as granting of personal hearing is concerned. Now, what are the outcomes of the appeal? What are the possible outcomes of the appeal? Please see, in appeal, normally a government servant may always appeal that his penalty, if it has been imposed, may be condoned or reduced, but the outcome of the appeal could be anything. Now, the appellate authority may confirm or enhance or reduce. So he can confirm the order of the disciplinary authority, original authority, or he may enhance, he may also increase the penalty, or may reduce the penalty, or he may set aside the order of the original authority, or he may remit the case to the original authority or any other authority with directions, whatever suitable directions. That means if he feels that the inquiry has not been correctly conducted as per the procedure, etc., he may pass any special direction to the same authority or any other person. Provided that if he is increasing the penalty, enhancing the penalty, in that case, if it is major penalty, earlier let us say a minor penalty was imposed, but the appellate authority wants to impose a major penalty on the government servant. So it's a case of a minor to major, or in other cases, within the minor, the penalty is proposed to be increased, or within the major, suppose earlier the penalty of reduction in rank was imposed and now the appellate authority wants to impose a higher major penalty of dismissal. In that cases, let us divide these into two issues. One, if he wants to impose a major penalty, in other cases where the penalty is being imposed within the minor or within the major, what he has to check is whether the earlier proceedings were done under Rule 14 or not. Rule 14 is for major penalty. So if major penalty procedure was followed, this is the first thing he should do if he wants to enhance the major penalty, or if he wants to impose a major penalty, earlier a minor penalty was imposed. Maybe a major penalty proceedings were started. If it was held under Rule 14, then it is okay. If he wants to impose a major penalty, but the proceedings were not conducted under Rule 14, in that case, he will have to first hold an inquiry under Rule 14. Of course, subject to Rule 19, where we know that inquiry can be dispensed with under three conditions: where a person has been convicted of a criminal charge, where it is not reasonably practicable to hold inquiry, and the third is where the security of the state is involved. There is no need to conduct inquiry in those cases. It can be dispensed with. Other than this, if inquiry was not conducted under Rule 14, the appellate authority will have to hold an inquiry under Rule 14. If he wants to impose a major penalty and earlier proceedings were conducted under Rule 14, no problem. Even now he cannot impose a major penalty. He will have to give the government servant a opportunity to represent. So he will have to provide an opportunity to represent against the enhanced penalty, take his representation, consider that representation, and then decide what penalty he will impose. In other cases also, the same procedure will be followed. That means the appellate authority will provide the government servant an opportunity that I am increasing the penalty from this to this. Please submit your representation, whatever it may be, by giving him a reasonable time. Now the next rule 28 says the order of the appellate authority, whatever order he will issue, the authority which made the order appealed against shall give effect to the orders passed by the appellate authority. So it is the authority which against whose order the appellate authority is now passing order. That authority will now implement whatever orders have been passed by the appellate authority. So you have understood what is the first remedy which is available after discipline authority passes the penalty order is appeal. So that is the first level, and that is the first level of remedy after the penalty. The second level, if you remember, was revision, and we will talk about revision in detail. It is covered by Rule 29. So earlier this Rule 29 was about review, but after the R.K. Gupta case, Rule 29 has been provided for revision and not for review. Review is the next rule which we'll talk about shortly. Now revision and review are different. So revision is distinct from review. What we will talk about, who can do this revision and when can it be done and what are the possible outcomes. Please remember that power of revision has been granted to many authorities under the Rule 29. However, the review, as we discussed earlier in great detail in the previous video, the power of review rests only with the President under the CCA rules. So only the President can review his own order. Nobody else can review his own order. So appellate authority, suppose he passes an order and he wants to review his own order. He can't do it now. Discipline authority passes an order and he feels, oh, I now want to enhance the penalty, or oh no, I want to exonerate the government servant. He can't review his own orders. Only the President can review his own orders. So the power of review rests only with the President, and that also, remember those two things. He can review only and only if there is a new material or evidence which could not be produced is now available. And not only that, it must be combined with the second condition, which is that it must have the effect of changing the nature of the case. However, for revision, what we are now discussing, no such condition of new material evidence is necessary. Revision can be done without these conditions also. Now, who are the revisionary authorities? First of all, under our rules, President, being the head of the executive, has the power of revising the orders. But remember, President can revise the order, not his own order, but the order of his subordinate authority. So, and the Rule 29 also provides other authorities in case of postal board, etc. Interestingly, the revisionary authority, appellate authority, is also revisionary authority. That means, now that this causes a little bit confusion. I'll talk very briefly about it. Suppose a government servant, after having been exonerated, does not submit any appeal. Obviously, he will not submit any appeal. But the appellate authority feels that the government servant has been exonerated for extraneous consideration, or he has been given a lesser penalty than which ought to be imposed on him. In that case, even if appeal is not filed, the appellate authority can review the order of his subordinate under the rules of 29 as a revisionary authority, because appellate authority cannot consider an appeal unless an appeal is made. He cannot do it that suo moto. But in the revisionary capacity, he can suo moto call for the records and increase or reduce or exonerate the government servant even if he has not appealed. So this is a very important, appellate authority can do it, but he can do it within 6 months from the date of the original order. So if he doesn't use his revisionary power within 6 months, he can't do it after 6 months. So the authorities are president, other authorities mentioned in the rule, appellate authority, or any other authority specified by the president. Within such time as specified, president can issue orders under the CCCC rules. So these are the authorities who can do the revision. Now, revision, as I told you, can be done on its own motion or otherwise. That means even if an appeal is not made to the appellate authority under the revisionary authority's power can call for the records and increase or reduce the penalty. Same is the case with the president. For the president, there is no time limit, kindly see, no time limit. But for the appellate authority, there is a time limit of 6 months. Now, what are the outcomes of the revision? Same as in case of appeal. That means the revisionary authority can confirm, modify, or set aside the order. He can confirm, reduce, enhance, set aside the penalty already imposed. He can impose a penalty if no penalty was given earlier. Now, this is exactly what happened in the case of R.K. Gupta case. He was exonerated and by the president, and the president himself now imposed a penalty. The courts held you can't do it. The court said under revision you cannot revise your own orders, but of course you can revise subordinate's order, and if the subordinate had imposed no penalty, the revisionary authority, that is the president or the appellate authority, can impose a penalty although no penalty was given earlier. He can also order for imposing or enhancing penalties subject to providing the opportunity under Rule 14, etc., that we have already seen, same as in the case of appeal. So to conclude, the same diagram that I had shown you in the previous video, a comparison. Now you can see appeal, revision and review. Now if you see the first column, appeal, it is by the appellate authority. It can be done. How it can be done? It can only be done on an appeal by the individual. So appellate authority cannot suo moto consider an appeal. Only if the charge officer submits an appeal, only then he can hear that appeal and decide the appeal. It can be done only after 45 days. So the appellate authority will have to, within 45 days, authority may hear the appeal. So the time limit for hearing the appeal is only 45 days, after which it cannot be heard by the appellate authority. However, he can condone it. Coming to the second column, revision. As I told you, president is the revising authority, but only for the orders of his subordinates. Revisionary authorities also includes the appellate authority, but appellate authority cannot revise the orders after 6 months. This is very important, again remember. So appellate authority can revise the orders of the disciplinary authority within 6 months of the original order, not after 6 months. But now this is important. He can revise the order on his own by calling for the records on his own, although no representation under revision has been submitted by the charge officer. He can revise the orders on his own. Coming to the last column, review. Only the president can do it, again on his own motion. Although no representation or submission has been made for review, the president can do it on his own. He can do it anytime. There is no time limit. 1 year, 2 year, 3 year, anything. Nothing has been there in the order rules provides for any outer limit. And as I told you, there has to be a new material or evidence which could not be produced at the time and which must have the effect of changing the nature of the case. So thank you very much. This is all about the appeal, revision, review. We'll meet next time with a new video, with a new lecture. Thank you very much.